and in relation to the consequence, the person means to cause the consequence. And to prove if there is intent or knowledge on part of Colonel Joy, we will base it from the given facts of the case. And it was very evident that there was no intention on part of Colonel Joy or even cause the death of the prisoners. The evidence presented with the prosecution that Colonel Joy had knowledge of the separation of prisoners and that difference in the treatment is not a sufficient proof. The separation of the prisoners was only for the purpose of giving religious instruction to those who pledged faith to Wasteland religion, and it does not show any intent that Wasteland would like to cause injuries or death among the non-believers. On the facts of the case, particularly paragraph 2.2 of the problem, the opposing party have misled this court on the real facts of the case. The prosecution claims that there was a clean act at Camp Q, but what actually happened was that there was a riot that occurred in the absence of Colonel Joy, and it was started by the prisoners, which resulted in injuries and deaths of many Wasteland soldiers. So there is no intent on the part of Colonel Joy or his soldiers to cause injuries or deaths on the other prisoners. It was only done to stop the riot, which, if not immediately abated, it will cause greater destruction. And the defense holds that such riot was really vicious because that in order to stop the riot, injuries or deaths are already expected, and the Wasteland soldiers assures that their act of abating the riot was not greater than what could have happened if the riot was not stopped immediately. So the abatement of the riot, resulting to deaths and injuries of both Wasteland soldiers and the prisoners, was necessary and reasonable.
Clarification: was the killing of the internees captive was done by the prisoners themselves or by the men of criminal?
Since there was already a riot, it cannot be identified. It is possible that the deaths of the prisoners and the soldiers was both committed by the prisoners and the armies of Colonel Joy.
It would appear that Camp Q was guarded by the men of Colonel Joy. However, if there is the contention that Colonel Joy is not liable, what would be the situation at the time that you can tell this court of the killing of the internees of the prisoners?
Colonel Joy would be liable if the intention of the soldiers in causing death or injury was, if that was intentional really to kill those prisoners, but it was not intentional because it was only done to abate the riot. Also under that submission, on the principle of command responsibility, the defense holds that Colonel Joy is not guilty of the crime as charged. Under Article 28 of the Rome Statute, a military commander or any person can only be liable for the acts of his subordinates if that military commander either knew or owing to the circumstances at the time should have known that his forces were committing or about to commit such crimes. And the defense admits that the acts of the soldiers does not constitute a crime of willful killing because, as I have said, Your Excellencies, the acts of the soldiers was only to stop the riot in order to avoid further injuries and deaths. And evident on the facts of the case, particularly also, yes,
when you say the acts, you refer to the result, or are you referring to the means? Especially people were killed, right?
The means, Your Excellencies.
Okay. Proceed.
Your Excellencies, also under paragraph 2.9 of the problem, during the exchange of prisoners, most of them testified that to the Amnesty International that they were all aware that all of the prisoners at Camp Q were moved out. So the prosecution who claims that there was a clean act, those prisoners who were exchanged could easily give statement proving that there was really clean up, but they didn't because there was really no clean up because the acts or the means done by the Wasteland soldiers soldiers was only to stop the riot. And finally, on that first submission, the act of the baseline soldiers under the command of Colonel Joy does not constitute a ground for excluding criminal responsibility, particularly Article 31 of the Rome Statute, that if the conduct which is alleged to constitute a crime within the jurisdiction of the court have been caused by juris, as in the case the riot resulting from a theft or imminent death or continuing serious bodily harm, provided that the person does not intend to cause greater harm than the one sought to be avoided, said act is a ground for excluding them from criminal responsibility. That's all. If you have no further questions, I give the podium to my co-captain. Thank you, Your Excellency.